I am satisfied that a fit sentence recognizing the significance of these offenses is as follows. For count 1, a sentence of 6 months jail. For count 2, a sentence of 1 year jail. And for each of the remaining 4 counts, the maximum sentence of 2 years per count. I am satisfied that because each set of offenses relate to separate remains and were separate acts, that each sentence ought to be served consecutively to the other. Totaled consecutively, this would lead to a sentence of 9.5 years. Section 718.2 sub C of the Criminal Code sets out that where consecutive sentences are imposed, the combined sentence should not be unduly long or harsh, otherwise known as the totality principle or the one last look principle of sentencing. The Crown submits that taking into account the significance of these convictions, the total sentence imposed would not be crushing and should not be reduced for totality. I do not agree. Giesbrecht has a family, including 2 children, and is employed. A sentence of this length could be considered crushing. In my view, a one last look at this sentence ought to reduce the total sentence by 1 year to one of 8.5 years. I sentence Andrea Giesbrecht to serve a global sentence of 8.5 years. Giesbrecht is entitled to credit for the times she remained in jail from her arrest on October 21, 2014, until she made application for and was granted bail. She behaved well in jail and is entitled to 1.5 days credit for each day of pre-sentence custody for her good behavior, and to recognize that she would have been eligible for early release if this time was served after conviction. She is entitled to an enhanced credit of 1.5 days, giving her 252 days or 8.4 months of time served. This reduces the remaining time to serve on her 8.5 year sentence to 7.8 years going forward.